Thank you very much. At this stage of the arbitration, we would wish farewell to the parties as they pack up their papers and leave the room, leaving the three members of the tribunal in the arbitration room with some time to sit down and discuss their views on the merits of the case. Now, sometimes this can be done and take 5 minutes, sometimes it can take an hour. For obvious reasons, it's not going to take us an hour now, but we will have a very brief discussion to give you a sense of what might be discussed in these meetings. Now, not necessarily, but quite often the third arbitrator kicks the ball off, and so we'll have that discussion now. I mean, my feeling is that I would look first at the question of, did I think there was any agreement? Because if there was an agreement, it could affect, obviously, what the parties were going to do. But my sense of the evidence was that there wasn't really an agreement. I would have been amazed if Trifilis had not sent something in writing if he felt there was an agreement. I don't know what you think, Chris.
Well, if there was an agreement in the terms alleged by Mr. Trifilis, that would be the end of the matter, because it would vary the terms of the Charter Party and we wouldn't have to go any further. The burden of proof, as I think Mr. Lauro made clear, is on the owners as the party relying upon this agreement. And frankly, impressive though both witnesses were, and reluctant though we are to criticize Mr. Lauro for his attempt to buoy up the evidence of his witness, I'm personally not persuaded that any such agreement was reached. It would be quite extraordinary for an agreement on which so much money turned not to be made these days without some record in writing. And frankly, as a general comment, one has to say that invariably arbitrations turn on documentary evidence rather than the evidence of witnesses. Simply because these days people do tend to record almost everything. That's so easy to send an email, and oral evidence tends to be, as we say in English, self-serving.
What do you think, Peter? Well,
I would agree with that, and my note of the evidence of Mr. Trifilis is that when he was being pressed on the point of whether there was an agreement and was asked what was he giving up, what were the Charters giving up? The answer was giving up, and then I have put ... He was able to meet the cancelling date of his next charter. That's my paraphrasing, but meeting the cancelling date of the next charter doesn't constitute an agreement to my mind. So once again, I do not accept that or do not find that there was an agreement reached.
So I suppose if that's the case, we've just fall back on the law and whether this is a Coral Sea case or not. I mean, my own sort of, in other cases, experience is that 40 days isn't anything particularly unusual, and I wasn't persuaded that there was anything unusual with the 40 days to take this out of the Coral Seas. Were you, Chris?
Well, I would agree entirely with that. I don't see any distinction in principle, but in the sanctified surroundings of this particular building, I have to make a small confession, which is that I was the arbitrator who wrote the reasons in the Coral Seas. In that case, I was actually appointed on behalf of the Charterers, and the provisions are identical. The difference is that in that case, we didn't have the benefit of an oral hearing and submissions from two eloquent and persuasive advocates. It was a question of trawling through the documents, and as I recall, because I did look at this, the award in that case I think was about 28 pages long, only 2 pages of which were devoted to the issue of the construction of the Charter Party that we've been looking at today. And the rest of it was all to do with the evidence that was put before us in documentary form about whether the performance claim was valid. But as it were, I feel I have to declare that, and I personally don't think that this case is distinguishable from the decision in the Coral Seas.
Peter, any different view?
And I should say, it's well established as a matter of English law that whilst one can look at the circumstances in which a charter party was negotiated, the factual matrix, as it's called, in construing the charter party, and if there is one construction that makes sense commercially and another which makes less sense or no sense commercially, then one is entitled to look at the commercial consequences. But what one is not entitled to do is to look at what the effect of what the parties have agreed in a particular case and say, well, that leads to such an absurd result that we can't possibly take that to have been their intention. And if I can just go back to the actual decision in the Coral Seas, I note that the judge, in considering the reasons that I drafted, actually said, and counsel for the owners said, that it would flout common sense, business common sense, to conclude that the speed warranty was unqualified, and actually quoted me as saying in the reasons that would be counterintuitive. But despite the fact that the judge accepted that it was counterintuitive and perhaps arguably commercially not very reasonable, that was the conclusion he had to reach as a result of the clear language of the clause.
So there you have an indication. What we would normally do then is we would agree who's going to write the award, and on this occasion it will be Mr. Moss.